Well, welcome to another episode of Ask Two Lawyers. Stuart, how you doing?
I'm doing good. Quick shout out to you and Eric, who did a fantastic job on Friday. And I really appreciate everything you guys did. And then I also want to shout out to the jury pool and to all of the awesome comments that I've received that have been heartwarming and touching. I've shared many of them with my family members who also are comforted by them. So I've chosen to just continue on working. We're getting ready for funeral arrangements and all of that, but it's been a very difficult time. But I will say you and Eric and the comments from the jury pool, they really helped me get through the weekend. So thank you.
Yeah, that was great to see. And I did see one comment where somebody said that at the beginning of the video, I looked like a hostage who was being forced to go on video. And I thought that was actually a very accurate description because it was a whirlwind of an afternoon and it was tough to be tough to be without you. But yeah, so much better that you're here, and I'm very happy that you're here. And I don't know that we were even really planning on going on today, except that we saw this issue with the Amicus Curiae brief that people, I think I saw a comment on our last video, and it got us to thinking. And we're like, maybe we should look at this and just out of curiosity, see if there's something here. Do you want to kind of tee up the issue?
Sure. So this comes from Federal Rules of Appellate Procedure, Rule 29. And there's some disclosures that the amici, the people that are filing the amicus brief, they have to give. And there's required disclosures. And if we look at the brief that was filed by the entities here, you can see here, Keith, that the footnote 1, they actually comply with Rule 29 of the Federal Rules of Appellate Procedure. And so they say, look, there's no parties counsel authored this brief. So in other words, Esra Hudson, anybody that represents Blake Lively or anybody else for that matter. But since these briefs tend to support Blake Lively, that's where we're going to focus on. So they have to have this statement that, Esra Hudson and that whole crew over there had nothing to do with this, and that nobody contributed money that was intended to fund the preparing or submitting of the brief, and that no person other than the amici or their counsel contributed money that was intended to fund preparing for this brief, and then none of the amici is a non-governmental entity. We don't need to get into the 10% issue there, but that's what's required. And I think what's interesting here, Keith, is that if you look at Federal Rule of Appellate Procedure 29, I don't know, Eric, if you can throw that up there. Yeah. And there's a requirement there. I think it's at 4 big E. And I don't know if you can make that any bigger or not, Eric. But the issue here is that this rule right here, it does not expressly require disclosure of a relationship that could bear on impartiality or credibility. And that's the issue that's being raised here.
So it talks about you do have to disclose a party's counsel authored the brief. If that happened, you have to disclose whether a party's counsel contributed money.
Right.
And then you have to say whether a person other than, I guess, amicus or a member contributed money.
Correct. But as far as is there a relationship that could cause a conflict of interest, technically it looks like you may not need to put that to be within the spirit of Federal Rule of Appellate Procedure 29, but there's a but.
Yeah.
But there's a but. But go ahead. You had a comment you wanted to say.
Well, it just seems odd to me.
It does seem odd to me. It does seem odd. And that's why, lawyers have to, not every rule is going to be written out expressly for us as lawyers. There are certain rules that we're going to have to, for example, we have a duty of candor with the court, which we'll get into in a second. So that may be something that's implicated. But so just at looking at the black letter rule in Federal Rules of Appellate Procedure 29, here it looks like at footnote 1, they disclosed everything that they were required to disclose, right?
On the amicus brief?
On the amicus brief, the entities. But you've got this CLWC, which is the California Women's Law Center. And there's a report that 2 of these lawyers are associated with Blake Lively. I have not confirmed the second one, so I'm not going to say her or his name yet. But we do know for certain that Esra Hudson is one of Blake Lively's attorneys.
Yes.
We know that, right?
Yes.
And we know that she also is on the board of the California Women's Law Center. And producer Eric is throwing that up there. If you look at the board of directors here, just scroll down towards the bottom, Eric, and we'll get to Esra Hudson. There she is.
Okay. And that Phelps and Phillips. So we know it's the same Esra Hudson.
Yes. And, this isn't all that difficult to even find. And so it boggles the mind a little bit, Keith. Like, what were people thinking at the CWLC that were going to come in and do this amicus brief and
Right.
sponsor it and take a position that they were giving the court some independent ideas here and not disclose that Esra Hudson is part of this. What about her profile?
It does say it. Yeah, I searched here. It does say it just on her Manat page too.
Look at that right there, right on her board. I mean, this kind of blows my mind just a little bit because you've got Manat, Phelps, and obviously a rock star law firm. They're huge, right?
Yeah.
And here on her profile page, she actually has that she is a board member of this entity, and yet this was not disclosed in the amicus brief.
So I want to point out some language from Baldoni's response to the amicus brief that I think we did review when we were doing the video on Friday. And he points out a case where it specifically says an amicus should present its position as an objective, neutral, dispassionate friend of the court. So I guess what you're getting at is this doesn't appear to be neutral when you have one of the counsel who's on the board of directors of that entity.
Right. Right. And this counsel actually has it on her bio page at her law firm that she's a board member of this entity. And so even if she stands up and says, I had nothing to do with the filing of the brief, I didn't talk to anybody about the filing of the brief, she's a board member of an entity and she represents a party in a case. And you would think at a minimum, you would throw down in that footnote, oh, by the way, Judge, yes, we've met all of the disclosures under Federal Rule of Appellate Procedure 29. We also want to point out that Esra Hudson is
one of the counsel in this matter.
Yeah, she's at board of directors, but here's why we can file this because, there was a wall put around her, whatever, or maybe just not have the CWLC be part of this because they're tainted at this point in the sense that, hey, this doesn't seem like it's an objective, independent review of the law. It sounds like it's just a party getting their arguments for a second time at this late stage. And by the way, I thought you did a good job, Keith, of pointing out, you and Eric both, that the timing of this amicus brief is really bad.
Yeah.
Because the briefs have been teed up for a long time now. The court's maybe getting close to giving us a written decision. We don't know what's happening behind the scenes. And there's this late filed amicus brief that's very beneficial to Blake Lively. And it just smacks of unfairness. How would you feel if you had worked your tail off on a case and it was briefed before the court and at the last minute, some other law firm came in and explain to the judge of that court, here's why Keith Davidson's brief is no good and here's why he doesn't win.
Yeah, I mean, it would be infuriating. And at the very least, you'd want an opportunity to respond to that. So now you've got a whole new briefing schedule that would have to happen and a response to the amicus. And then they would probably want to do a reply. But yeah, it would be infuriating. Now, if it happened close in time to when the original motion was filed, the 12B6 motion that Lively filed, at least then you can deal with it part and parcel with the arguments that are already being made. But to come in 2 months after the fact, I mean, that would be infuriating.
So there's a timing issue. And then to me, there's a disclosure issue here.
Well, and that's a huge issue in my mind. I mean, what kind of, so the best case scenario, so if you're on, Esra Hudson's side or you're on the Manat side, you're going to say, well, yeah, she's a board member, but she had no involvement in the brief. And she didn't, what are they going to argue? She didn't know it was going to be filed. I kind of find that hard to believe when, I'd find it hard to believe that the amicus parties just came in here and filed in favor of Lively without ever contacting their counsel or saying anything about it.
Well, they may not have, but I'm astounded that this could slip through when it's so easy to find, when it's on her actual profile at her website. She's actually at the CWLC's website. Her name this is not something that would take, an expert to find. This is pretty easy. Some simple Google searches will get you there. This should have been disclosed. And, look, there's either two things. One thing, this is just a colossal, embarrassing mistake. That's if you take it at its best, put the best face on it. But wow, how embarrassing. I mean, how could you miss this?
Right.
I mean, this is not, to me, it doesn't seem that somebody saw this and thought, oh, don't worry about that. It's not a big deal. Or they intentionally did it thinking that no one would find out about this. But I just can't imagine lawyers thinking no one's going to find out. All the people that are interested in this case, the public perception, the people who are watching, the court of public opinion. I can't imagine that this information wouldn't come out at some point. And so if you did know it was there, you would want to raise it with the court or tell the CWLC, hey, we don't need your help in this regard because we're conflicted out because we have Esra Hudson, who's a board member.
Yeah, I mean, at the very minimum, you should have disclosed it. And the attorneys filing this amicus brief should have thought to themselves, is there anybody that's associated with this case, counsel or parties, that are also in any way associated with these entities? I mean, that's just a simple question that you would ask.
Did Brian Friedman, in his letter to the court, did he, and we'll get to that question in a second, did he point out that there may be some conflicts here, some disclosure issues with Esra Hudson?
No, I didn't see that in the reply brief.
But your point is so well taken, Keith, that the people who drafted, the lawyers who drafted this amicus brief, because this is drafted by lawyers.
Yeah.
I do know that that there's a content creator that's drafting her own amicus brief.
Yeah.
What's her name?
Colonel Kurtz.
Colonel Kurtz, yeah. She's doing her own amicus brief. But lawyers draft these amicus briefs. Boy, how do they look if they didn't uncover the fact that this was an issue that needed to be disclosed to the court? Now, before we get to the question, Eric, there are some issues that we want to talk about here briefly, Keith.
I mean, this is drafted by a firm by the name of Katz, Banks, and Kuman out of San Francisco. So this is, and New York. They have offices in San Francisco and New York.
True or false, Keith? Amicus briefs should not be used as an advocacy tool by the parties.
That's true.
That's true. And so, true or false? Amicus briefs should be independent.
They should be.
Could this brief ever be independent without disclosing that Esra Hudson is a board member of the CWLC?
Well, no, it cannot. And that's the problem. I mean, even if you take it in the best possible light and say that somehow Esra Hudson didn't know that they were preparing this and drafting it, which I doubt. But even if you took it in that light, the minute you fail to disclose that, it taints everything. Let
me ask you this. When Esra Hudson saw that this had been filed, did she have a duty in your mind, or maybe decent, what a decent lawyer would do? Hey, I'm going to let the court know, by the way, I'm a board member of the CWLC, and I don't think they disclosed that, so I'm going to disclose that.
Oh, that's a really good point. That's a really good point. I didn't even think about that. But I think that, yeah, if you want to try to make sure that your client doesn't appear to be tainted in all of this, I think you would. I think you would do that.
And I would even do a declaration saying, I didn't know this was going to be filed.
Right.
I didn't have anything to do with this. I didn't know about it. Of course, the problem with this is the perception, right? It doesn't matter what you say if you're Esra Hudson. It doesn't matter what you say if you're the CWLC. If that potential conflict is there, you must disclose it. And really, they should not be part of the amicus in my mind.
It doesn't matter what you say, but it's also always better when you tell on yourself when there's a problem, because you're going to look at least a little bit more credible than if you don't say anything at all.
Yeah.
And I mean, I think that's pretty crazy. And one of the things that Friedman did point out in his response is not only was the part I read to you before that the amicus is supposed to be neutral, but really it's only supposed to be allowed when somebody's either not represented, not competently represented, or when the amicus has unique information or perspective. I mean, it's very narrow when you're supposed to use this. And then you come in and you file something on behalf of an entity where one of the lawyers is actually part of that entity. I mean, it completely destroys any look of neutrality right there.
So the independence prong is gone.
It's gone.
As far as the CWLC, just because people are going to have the impression, and it's not an unfair impression, and that is that Esra Hudson had something to do with this, or just the fact that she's on the board to curry favor with her, whatever the issue is, it's a problem for the CWLC being part of this amicus brief.
Yeah, it really is. And, it's funny because when you frame it like that, they didn't have to be part of this, right? There's two other entities, and I haven't looked into the other entities, but there's two other entities who could have filed this and made all the same arguments.
Right.
They didn't need this third entity to be there.
Eric, I may have missed the moment, but
no, it's okay. It was more just like a thought that you guys were on, and thanks for this comment. May Vang says, you guys compliment the lawyers on both sides. It's a very smart and calculate people. So why would they, make this mistake? It's just kind of maybe a hypothetical, or not hypothetical. What's it called? What's the name of the question?
We're just gonna let you dangle there.
Flounder.
Cue the Jeopardy music.
Use your words.
It's the question. It's the whatever. I can't think of it.
That's all right. Yeah, it is a boneheaded move, I think. I mean, these are smart lawyers on both sides, and then you see something like this happen, and you're like, "What are you doing? Like, this is not helping your cause to be doing something like this." But I do like your point that, even let's say Ezra Hudson had nothing to do with this. I think if she had gotten in front of it and filed something with the court, it'd be a good idea.
It makes it so that, like you said, Keith, like when you're telling on yourself, when we do a jury trial, although we're just estate planners, but when we do a jury trial, about 2/3 of the way through that jury trial opening statement, I start telling on ourselves. But I never say, hey, the defense is going to get up here and tell you X, Y, and Z, because I don't want to give the defense any credit whatsoever.
Right.
I simply say, hey, before we brought you folks here today, there were certain questions we had to answer for ourselves. And so we want to talk about some of those questions. And these are questions that hurt our case. So the first question is X, why is my client still here in front of you when this is an issue? And let me give you the answer. And so then you give the answer. And you do that for all the bad things in your case, so that when the defense attorney gets to get up and do their opening statement, and you can actually see the blood leaving their face as you're doing this, because it takes away their firepower, because they say it and the jury's like, yeah, but Mr. Albertson or Mr. Davison, they already explained,
said it.
They already explained all this to us. So if you're Ezra Hudson here, or if you're any attorney here, quite frankly, and you have a potential conflict of interest, just disclose it to the court and say, hey, by the way, I had nothing to do with this. Let me get out in front of it, but let me disclose that. And I'm not certain why that didn't happen here.
Yeah, it is a little shocking.
So the other thing is, we talked about the independence that the amicus brief, the amici are supposed to have. And then there's just the candor to the court, right? And so again, these are things that are not in writing. The court doesn't say, I have to always tell you to, be open and honest and brutally upfront with me on everything that you would think that I would need to know. I think a good example of this is, we had a service issue one time on a case, and the court didn't pick up on it. And we really wanted this case to go forward, but there was a party that wasn't served. And so the question for us was, do we serve the party now, which we're late serving the party, or do we have a duty to tell the court, oh, by the way, I know you're going to grant what we've asked for, but you can't because we have a service issue. That's the duty of candor with the court, right?
Right. Yeah.
And there's no law out there that says, oh, by the way, Albertson and Davidson, you need to notify the court that this notice issue didn't happen. There's no rule that's written down, but because we are officers of the court, we have to be honest and open.
Of course you disclose it, because you realize that within our duty of candor to the court, you wouldn't not tell them something so vitally important and basic as notice. So same here. I think this is so basic that you would have to say something.
So there's at least a part of potential bias here, right?
Yeah.
We don't know that there is a bias, but there's a potential for bias, and that's the problem. And then there's a potential for perceived partiality, right? I mean, isn't that an issue as well?
It is, yeah. And that's the problem with conflicts, is that you can have an actual conflict or you can have a perceived conflict, but when you fail to disclose it, there's really no difference. This could have just been a perceived conflict, but not an actual conflict, because maybe, we don't know the facts. Maybe Ezra Hudson didn't have anything to do with this amicus brief, but because it wasn't disclosed, it makes it appear as the worst type of conflict, an actual conflict. So that's the problem with not disclosing, is that the assumption is, oh, this must be the worst.
There's something smelling in Denmark.
Yes,
I think it was something. What did he say? I'm showing how smart I am with my Shakespeare.
Something rotten in Denmark.
Thank you. Yeah. Something rotten. I'm sure if it's rotten, it smells.
That's the presumption. Yeah.
So then finally, so we talked about independence. The amicus needs to be independent. And then they also, lawyers have a duty of candor with the court. And then you've got judicial scrutiny, just the way the court's going to look at this. And I saw a sentence here that I wanted to read, and it says the amicus should not be presenting a particular party's arguments in a different voice. I thought that was a nice way of encapsulating that.
Interesting.
So the amicus should not be presenting a particular party's arguments in a different voice. And so the worry here is, you didn't disclose this. The lawyers who drafted the amicus didn't disclose this through error or intentionality, probably error, which is embarrassing. Then Esra Hudson, you would think, if she would have seen the amicus and goes, oh my gosh, this is one of my entities, maybe she should say, hey, maybe I should alert the court about this. And then you've got the court saying, well, if you didn't disclose this to me and I see that there's this potential conflict, are you just regurgitating the arguments for Blake Lively in the form of an amicus brief? Which
makes sense, because the standard for amicus is when you have a unique information or unique perspective. And so, okay, that makes sense. Unique would mean you're not just saying something the parties have already said. So that's really interesting. I like that wording.
Yeah. So anyway, we saw this. Other people have already we're not the first to find this. This has been something that's been circling social media for 24, 48 hours now. But we did want to bring it to everyone's attention. And Eric, do we have any good questions from the jury pool on this one?
Yeah, got a few. Lauren's in Australia.
Oh, wow.
Oh, damn.
So that must be early morning, maybe 16.
Good day, Lauren.
By the
gosh.
way, rhetorical question. That's what I was looking for. I know you guys knew that, but I was like, rhetorical question.
Oh, good. Okay.
This was along the same. Have you guys seen 8 Mile with Eminem?
Yes.
He's like, this was in relation to you, Stuart, saying like you tell on yourself.
Yes.
And that's kind of what he does in his rap battle. He's like, I'm white and I'm from a trailer. So it's like no one else can get you.
Yep.
So I like that comment.
Yeah.
I'll keep thumbing through.
Thank you for keeping us current on our pop culture, Eric.
Yeah. I mean, that movie was like still 20 years ago. It's
a great movie
by now.
Yeah,
it is. Yeah. I'll keep thumbing through some comments here.
Okay. So one other thing that came up, Keith, and we were just coming on the show, and we haven't really looked in depth at this, but there was an issue about a letter filing regarding Blake Lively's medical information.
Yeah, so there's a letter motion filed by Friedman, and so they are trying to force Lively to hand over her medical information. And in particular, they want to compel Blake Lively to identify her medical and mental health care providers to produce the mental health records and to deliver to the Wayfair parties the necessary HIPAA authorizations to permit them to get those records. And apparently they've disclosed in this filing that in response, Lively's counsel have said that they're going to withdraw their intentional infliction of emotional distress claim, which they defined as an IED claim, which isn't that like an explosive device?
It is.
Okay.
Oh, yeah.
Is it?
Yeah.
Well, one of them is one thing and one of them is another thing.
They're both explosive, but yes.
Oh, okay. So anyway, we're talking about something different, which is the inflection of emotional distress. And
I would call it the infliction, but
yes.
I like deflection. That was good.
Deflection? Did I say deflection? But there's an issue because Lively wants to withdraw it without prejudice, meaning it could be refiled in the future. And of course, Friedman wants them to withdraw it with prejudice, meaning it's a done deal. But in terms of this whole issue, so they want her medical records. She's obviously not wanting to give them because who would want to give up, especially mental health records? And so instead, they're going to withdraw a claim. Like, what is the strategy behind doing something like that? What are they thinking?
So I don't want to say this happens all the time, but it does happen with a more times than you would think it would. And lawyers tend to bring every claim they can when they file a lawsuit, and then defense lawyers tend to throw in as many affirmative defenses as they can, and that's just the way it is. And that's because you're at the pleading stage. It's all new. Not everybody knows the facts, the witnesses, and the documents, and things are kind of foggy in the fog of war. So we just throw everything against the wall and see what happens. And here they brought an intentional infliction of emotional distress. Well, the defense are allowed to look into that and determine, was she really emotionally damaged? Well, the only way to do that would be to get her psychological records that show the baseline before she was injured and then show what happened afterward. Well, you can imagine the things that you tell therapists, the things that psychiatrists know about you. These are things that you do not want anybody to know about. And so then what lawyers do in many cases is say, hey, we're withdrawing that claim. And if we withdraw that claim, then you can't ask questions about that. And then whether it's with prejudice or without, I think a party could dismiss without prejudice. I don't know that you have to dismiss with prejudice. I guess the argument from the defense is, well, but if she brings the claim back at a future time, we want to know, we don't have to restart discovery. So let's just do it all now. If I was Blake Lively's team, I would withdraw it with prejudice because I am not going to go forward on that claim because I don't want to put my client through having their medical records looked at. And it's not just that you have to turn over the medical records. You might have to go sit with the defense's psychiatrist and have an independent medical exam done.
Yeah.
So you can have somebody talking to you that doesn't like you and wants to hurt you and wants to trick you. And then you have to have your deposition taken and people are going to talk about that. So this is a claim that I would say you withdraw it and you bury it as far as you can and you never bring it up again.
And I wonder if there's any other aspects to Lively's lawsuit where she's claiming any type of mental anguish or anything that would implicate these records, where these records would still have to be handed over. I know they've offered to withdraw this one claim, but is that enough?
If there's anything that deals with her mental damages, then yeah, the defense has a right to go through and see if there's merit to that claim. And so the smart move here is to withdraw it. I'll give you another example. Many times in a wrongful death case, somebody is taken to the hospital and the doctors do their best to bring the person back, and the person dies. So the damages are the car, and the car is worth $50,000. The damages, special damages, and then you got special damages for the transport of the ambulance to the hospital. That's probably what, $20,000 these days.
Yeah.
And then there's the doctors trying to save the person. Let's call that $50,000. So let's say it's $100,000 in special damages. Well, what's the life of that person worth? The life of that person is worth millions and millions and millions of dollars. And so many times you'll see plaintiffs' lawyers who simply won't ask for special damages in a wrongful death case, or like Blake Lively's attorneys are doing here, if they did ask for them, once they get the discovery, they withdraw the claim because they don't want to set an artificially low anchor with the jury. $100,000 in special damages. Special damages are anything you can put a receipt to. And then you're going to ask millions of dollars for wrongful death, and the jury just doesn't get it because it's only $100,000. So this kind of withdrawing of claims, this happens with the affirmative defenses too. The defense lawyers figure out that the affirmative defense is not a good one anymore because they plead like 30 of them, and they start withdrawing 2 or 3 of them during the discovery process. It's the natural order of things, and it actually limits the amount of issues that are going to be put before the jury at the time of trial.
Yeah, and it makes sense because when you file your lawsuit, you're supposed to bring all claims, all known claims. And, so you're your hands are tied that you're supposed to plead all known claims. You don't know which ones you're ultimately going to go forward on once the evidence comes in and all that. But I could see why you would want to withdraw something like that. And reminds me of a case that we had, if I can just tell this story.
Yeah, tell us.
And it was a really great client we had. She was a great lady, older lady. She was a Marine Corps veteran, had been in the Marines for years and years, married later in life to this man, great guy. He had kids from a prior marriage, and they weren't married all that long. And unfortunately, they went on a vacation, and he just suddenly dies of a heart attack. Just horrible situation. But because they were married and because of the way things were situated, our client was going to get a portion of the estate, and the kids were going to get the rest. And the kids weren't happy about that. They didn't want her to get a dime. And so they were just horrible to her. And so we had to file a petition and enforce her rights. And not only did they object to what we were doing, even though we couldn't figure out how they had any basis, to even mount an objection, but they did. But they took a very nasty step, which is they called the police in the location where the couple had been vacationing when the husband died, and they filed a police report saying that he was murdered by his wife. Murdered.
And gave all kinds of details.
I mean, it was absolutely outrageous. And to think that this lady would murder anybody, it's just it's certainly not her husband. And there was, zero evidence of it. But still, the police had to take it seriously, and they did an investigation, and we had to hire an attorney. We hired a criminal attorney just to kind of advise us, just to be sure everything was okay. And everything was fine. The investigation obviously found nothing because she did nothing wrong. So then we wanted to take the deposition of one of the kids who had
reported the murder.
Yeah, reported the murder. But they didn't want to sit for their deposition all of a sudden. Well, I wonder why, because they didn't want to answer questions about that. So instead, they dismissed their objections, and they just got out of the case. And, it was so disheartening and disappointing when that happened because, we really were looking forward to that deposition. But it was great for the client because once the opposition went away, then we could get the relief that we were looking for without any opposition. And everything ended up turning out really well for her. But man, what a terrible thing to do.
I that's a great case, Keith, where it's a good example of somebody withdrawing a case that actually ended that case.
Yeah.
But you and I did some discovery, and I think we did this, and this was based on some things you've done earlier in your career. But we defined the police report as the false police report.
Yeah.
And so in discovery, when we sent it over, we said, give us all facts that support your false police report that you made
Right.
on this date. Give us all witnesses, give us all documents. And so ultimately, when it came time to sit for the deposition and to produce discovery, they just chose to withdraw the entire lawsuit, ended the lawsuit.
They went running for the hills. Well, strategically, it was probably a great decision on their part because, quite frankly, they weren't going to get anywhere at their objections anyway. And why sit for that?
Right.
But in terms of, putting our client through the paces, it was not pleasant for, a while there.
Yeah.
But, we fought through it. So, I mean, it's interesting to see what's going on here and the strategy that they're using. And I could see why Friedman would be not pleased with them trying to withdraw it without prejudice, as if they're going to file it at some point in the future.
They should just withdraw it with prejudice. You're not going to bring that claim forward. It's hard to get through. You're going to put your client through an enormous amount of stress. And it's not even that valuable of a claim, in my opinion. But we'll see what happens.
Yeah.
Is this I had seen this name before, Casey Kasem?
Yes.
Oh yeah.
Yeah, he was a
radio personality.
Yes. Yeah.
Wow, you're so young. You don't remember Casey Kasem?
No, I do. I remember
Okay, good.
when I was younger, and I remember hearing that name. But do you know much about this?
I just know that somebody kidnapped him at the end of his life, and they stole him, and they drove him around to keep him away from people. Was it his wife or somebody did?
I think his wife. Is a big conservatorship fight between his wife and his kids. It was a really terrible thing. Is something similar happened to was it Mickey Rooney?
Mickey Rooney, yep.
Yeah.
We know the attorney that worked on that case. In fact, he was just talking to you the other day.
Yeah, really horrible situations.
Yeah, it seems horrifying. Do you guys know anything? Has anything happened with Jed Wallace? I feel like I'll see some comments here and there, but Johnny says so. She exposed Wallace's health conditions, but has kept her health details hidden.
Yeah, I have no problem disclosing your medical records. I just don't want to disclose my own.
Yeah. People don't like to disclose those things. Yeah, that was again Jed Wallace. I have not looked into Jed Wallace recently, Eric, but he's the one person I really feel sorry for in this case. And so until I see evidence to the contrary that he's some type of bad person, I just feel bad for him. I feel he got dragged into this, and he's having to spend a lot of money on lawyers, and I'm sure this is not good for his health.
If you guys are representing Baldoni, would you bring up the Esra connection? John also says during the deposition.
Oh, sure. Yeah. In fact, I'd be looking at Esra Hudson the whole time I was talking to her client. But yes, you'd want to bring this up in deposition, and you'd probably want to spend some time on it. But there's so many things that Baldoni can do here in the depositions based on what we know about the facts thus far.
Yeah.
And you've said all along that, your opinion is that Blake Lively cannot sit for her deposition. You think this case must settle before she sits for her deposition.
It's going to be tough for her. I mean, I'm sure her lawyers will spend a lot of time preparing her, but it is hard to go through a deposition, especially when you're opposite a guy like Brian Friedman or, or whoever takes her deposition. I know they brought in a female partner at Friedman's firm, but they're going to be very well prepared, and it's not, it's not easy. I don't think it's going to go well for her.
Yeah.
Any reason to believe the judge might open discovery for the New York Times?
I think the stay's in place right now, and I think it stays there. What are your thoughts?
I think it stays there. Yeah, I mean, they have a pretty strong motion to dismiss, and I'm thinking the judge is thinking that as well. But we'll find out. I mean, sooner or later, he'll make his rulings. So
yeah. By the way, these amicus, if you think about it, they could end up backfiring on 47.1 to some degree, because I think that Esra Hudson did a very good job, as I pointed out in her briefing with the court in her 12B6, describing how 47.1 and also 47 works in this case and how it helps her client. Well, now, boy, this has just turned into kind of a storm of it's not as clear as it needs to be. Now I'm going through what Eric's going through a few minutes ago. My words aren't working for me.
In other words, these amicus could be coming in muddying the waters.
Muddying the waters. That's what I was looking
making
for.
It so the argument isn't as kind of clear cut and hard hitting as maybe Ezra's brief was.
That's right.
And that might cause the judge to think about this a little bit more.
Right.
Can I put one up, Eric?
Yep. Go for it.
I don't know. Can I? I guess I can't.
I was looking at this one. Were there any sanctions for medical disclosure? Sanctions for his home address? I don't know. I don't think anything that we saw.
I haven't seen anything.
Yeah, I didn't see any sanctions for that yet. I know there's motions to dismiss, and that he's involved in the Texas case, and I think there's still the judges has yet to rule on that.
While you're looking for that, Keith, I still think 47.1 is an issue, and I know people say we harp on it. We don't harp on it. We talk about it because they keep bringing it up in the case, and rightfully so. I did notice that somebody had commented on one of our videos that And apparently this person's a lawyer and had said that, you guys don't really seem like you know what you're doing, which you're entitled to your opinion. We may not, who knows? But that you guys don't know what you're doing. And I have tried, I don't know, it was 28 jury verdicts or something, something to verdict, 20 trials to verdict. I don't know. Somebody find the comment out there. And that, you're just too afraid of 47.1 and, you don't know what you're doing. And the only thing I would say to that, Keith, is you and I are good friends with some of the best trial attorneys on the planet. They're here in California, some of the best trial attorneys in California. And, some of our friends routinely hit $200 and $300 million in verdicts per year. But they'd be the first to tell you that they lose cases.
Yeah.
And they win some big ones, no doubt. And they do really well and everybody likes them. And, of course, when they go to continuing legal education seminars, they only talk about their winners, which I don't blame them for that. You don't want to talk about your losers. I have had some of them get up and talk about how they've let people down, not intentionally, but they lost a case and it just, they couldn't sleep for weeks afterward. But anybody that has won has won millions and millions of dollars for their clients, they've also lost cases for clients. And, you don't get to take all winners to trial. And so that's the point of 47.1, or anytime your client is set up to be harmed if they don't win the case. And here it's stacked against Justin Baldoni. The second case, the defamation case, is really stacked against Justin Baldoni. You have to sit down with your clients. You have to explain what can happen. And look, even billionaires, yes, they can afford. Elon Musk, he had to give up at some point in Washington, right? He had to give up.
Yeah.
He couldn't stay there. Tesla,
Right.
the share price was falling.
Right.
People weren't buying Teslas anymore. He finally, he's a richest man on the planet. And even he had a breaking point. Hundreds of millions of dollars, that's a lot of money if you have to end up owing that, and you have to have that discussion. So in response to that person, I'm glad that you won 20 jury verdicts and they were all, whatever they were, 8 figures. But what did you lose? Tell us about your losing cases. And did you ever have to tell your client, hey, I bankrupted you. Sorry about that.
Yeah.
Did you ever have that discussion with a client? It's one of the hardest discussions you'll ever have.
No, if you're truly a warrior, you're going to have some losses. You're going to have some battle scars. It's just the way it is. But there's a huge risk attached to 47.1. And anybody who says that it's not a big deal, well, that's fine, because you're not the person who's suffering what the risk is. So if you want to call up Baldoni and indemnify him to pay him for the punitive damages, attorney's fees, and treble damages, then you can be the one to make the decision. But if you're not in the hot seat, then, we're just all Monday morning quarterbacks, and that's all we are. And us too. I mean, everybody is. But I don't think you can look at that and say, it's not that big of a deal. Okay, well, but you're not the one who's living under that risk, are you? So it's easy to say when you don't have the gun, the barrel of the gun pointing down your forehead. It's easy to make those comments.
Right.
So I'm trying to get to this comment by Telly O at 4 p.m., Eric, but I can't seem to make it come up.
Can you double click it? Show? Nope.
I'm getting there. Hang on.
You got to go back a ways. So there it is. Thank you. Yeah.
You can read that.
Can you explore the line of thought where Ezra knew it looked bad, but did it anyway? Are there benefits for Lively that we're overlooking? So is there some instance where Ezra would have known that this was happening and known that it probably wouldn't look great, but that's okay, go ahead and file it anyway? Because I can't think of any. I mean, it seems like if you're in the position of saying, well, go ahead and file it anyway, I would say go ahead and file it anyway, but put a footnote in there that I'm on the board. Would have been a better way.
Well, my gut tells me, and I don't know this to be true, but my gut tells me that Esra Hudson's going to say, I had no idea this was even going to be filed. But if that's the case, did you notify the court once it was filed? Because you know that somebody's going to jump on this. You know it's going to look bad. And let's say that everything's innocent here. I'm not saying it is, but let's just assume everything's innocent here. I feel bad for the other two entities that put all their time and effort into this. And then, but I still think you made a great point the other day. Aside from this potential conflict issue and disclosure issue, it's a timing issue.
Yeah.
And that's a very strong argument as well. I thought Brian Friedman did a good job of pointing out, hey, this just isn't fair at the end of the day. This shouldn't be coming at this timing. And if you're going to accept it, Judge, then you got to let us have another shot at the apple, or another bite at the apple too. And it really complicates this.
And it's an easy way for the judge to get out of the situation and just say, based on timing, I'm not going to allow it. and it's a valid argument. It's germane that because it was so late, and it's an easy way to rule without having to get into any other merits.
Yeah, that's true. Anything else?
I like this one. This may be a dumb question, but is there a reason the courts do not involve lie detector tests? I'm thinking Maury Povich could have solved or simplified this before even getting to a commercial break.
Yeah.
Was Maury Povich the one that would take the lie detector test of the potential dads or moms?
That's
or was that somebody else?
That's like, yeah, you are not the father.
Yeah.
That's not Springer.
No. Well, Springer had all of it, but but I thought there was one.
I think it might have been Maury.
I think it was one where they took lie detector tests, and then the woman, no, I'm not lying. It really is your baby, and the man's like, oh my gosh,
Any funny stories about lie detectors? I mean, I don't know. You guys can.
I mean, it's just not the way our system is built. We have an adversarial system. Each side is supposed to bring in their arguments, and then the trier of fact, which is in this case the jury, but in some cases it's the judge, gets to parse through those arguments and that evidence and decide what the true fact is. And that's just the way that our system works. There's other systems in the world that don't work that way. There are systems where the judges are the ones that go out and do an investigation and try to determine the truth. But that's not our system. So as we're reading all these things, of course, they're adversarial and they're advocating for their position. But ultimately, it's the trier of fact that's going to sort all this out for us.
Yeah, that's true. And I think there's a lot of research and data out there on lie detector tests. They're just not reliable. At the end of the day, they're not reliable. The CIA uses them. They use them on their own employees. The FBI uses them. But yeah, they're just not reliable. It's the problem. You can be trained to potentially beat the lie detector test.
Oh, really?
And apparently one of the methods is to bear down, like you're trying to go to the restroom. Apparently that's where your brain goes, and you lie away, but go ahead and lie and have fun with it. But
keep that in mind.
But they're just, the courts and credibility is important. We want to hear what people have to say, and then human beings are going to be the judge of people and determine, are they credible or are they not credible?
Yeah, that's right.
Gigi wants to know, I think I'm confused with opinions that 47.1 denies a party due process. Is that statement true?
I don't know how it denies somebody due process, Keith. I mean, it certainly inflicts an enormous amount of pain on people. And the question is that constitutional? That you can just go ahead and tee somebody up for treble damages. And I think that's more of a free speech issue, though, isn't it? Isn't that First Amendment issue about whether you are allowed to petition the court with your grievances? And here you really can't, because if you petition the court with your grievances of defamation and a sexual harassment claim, or somebody sued you for sexual harassment and you're filing for defamation, it takes away your First Amendment right to make that claim, right?
Yeah, but I think it does impinge on due process to some extent, but doesn't all anti-SLAPP do that? And so then it begs the question, what is due process? And 47.1 will take, if it were successful in this case, for example, it will take away Baldoni's ability to continue his lawsuit all the way to jury trial for defamation against Blake Lively. That will be removed from him. Now, you could say that, well, he had due process because he still was able to file it and he could make his arguments. And if he showed the proper allegations, then he could have gotten through, but he didn't. And so, he didn't get through. That is, so he did have due process. He didn't but he didn't have as much due process as claims that go all the way to jury trial. The same thing with anti-SLAPP motions, where you have to have a showing that you have a reasonable likelihood of succeeding on the merits. You don't have to do that with any old lawsuit. Most lawsuits, you don't have to have a showing they have a reasonable likelihood of succeeding on the merits. That's what trial's for. And yet, when you're facing an anti-SLAPP, you do have to do that. So it does curtail due process to some extent. But I think the issue is that as a society, the legislature has decided that that's okay in this particular context because of the abuse that people have used defamation lawsuits against victims in the past. We're going to try to shut this down. And some people are going to get caught up, in the process and not get their fair shake.
Right. Yeah, and there are attorney's fees with anti-SLAPP. It's not as onerous as 47.1 because there's attorney's fees plus treble damages plus punitive damages potentially on all of those damages. And so what you're saying is you really have to risk walking across a minefield in order to bring your claims.
Yeah.
And so that's quelling. What am I looking for?
It's definitely putting
Chilling.
Yeah, it has a chilling effect.
Chilling
yeah,
effect,
you can still exercise your due process, but be prepared to pay for it. Versus some other lawsuit that doesn't implicate that, where you don't have to do that. So there's different levels of due process in that sense.
Yeah.
When Blake Lively tries to settle, can Baldoni force no NDA so she doesn't go on forever excusing herself? That's an interesting kind of thought.
Well, Keith, we settle lots of cases, and there's these clauses that come up that sometimes we want them, sometimes the other side wants them. What are they, and how hard are they to get?
Confidentiality is the big one. And that's when you're talking about an NDA, a non-disclosure agreement, you're talking about confidentiality. And anytime that we're negotiating a settlement, we try very hard not to have confidentiality in them for a number of reasons. The number one biggest reason is you're going to buy yourself a future lawsuit, because somebody's going to say something to somebody because they forgot about the confidentiality clause, and then boom, you're going to have a lawsuit on your hands. So just don't have it.
Right.
I mean, why have it? But I would imagine here that's going to be a big issue. And I imagine maybe both sides want it, but I couldn't imagine this settling without some form of confidentiality.
Yeah, I think what both sides would want to have confidentiality to some degree, and that'll be difficult too. I mean, there's so many things that are going to be difficult to resolve in this case, but that'll be another issue they'll have to resolve. Is, are we going to do confidentiality, and then how does that work going forward? Do you file a lawsuit when you think that somebody has breached the confidentiality clause, or are you required to go back to the mediator, and are you required to privately arbitrate? I mean,
and what are your damages? Are you going to set the damages,
right,
like liquidated damages,
right,
they call them, or are you going to litigate it out?
Yeah.
I mean, oof,
yeah,
what a nightmare.
big issues.
Can the judge still decide to use New York law in this case? And would 47.1 still apply because of the CRD complaint?
Well, I think that the court can use New York law if it chooses to. I mean, it's a choice of law analysis. And you've pointed out, Keith, that the court can use choice of law for one cause of action, and then use New York for one cause and use California for another. But my gut tells me that the court's going to use California law here. What are your thoughts?
I think so. I mean, Baldoni has argued for California law in their defamation suit against the New York Times. So I think it's kind of hard to then say, but I don't want California law in my defamation lawsuit against Lively. So the court could use New York law. If it did, 47.1 would not apply, I don't think. I can't think of how it would. But I think that's unlikely. I think the court's probably going to use California law and then make the decision from there.
Yeah.
Maybe just another kind of clarifying, I think we've talked about this with our graphic, but Baldoni's defamation doesn't stem from Lively, but rather Reynolds and Sloan being her agents in Baldoni's opposition. Why is this being overlooked? Or you can, explain it better, how it's all kind of baked into one.
Well, I guess I don't understand. Are they saying that Baldoni's defamation, it's in response to the sexual harassment complaint that was filed by Lively? No?
That's part of it. So there's two aspects to it. And we did cover this, and I don't think we overlooked it, but I think there's defamation in the sense that her statements on the sexual harassment statements are defamatory according to Baldoni. So that's directly against Lively.
Right.
But they also argued that Reynolds and Sloan were agents of Lively, and that's another form of defamation. Imputes it,
right? Which
we covered that when we went over the 12b-6.
Yeah,
and we actually thought that was a rather ingenious argument at the time. I still kind of think it is.
Right.
So that's another way that she could be liable for defamation. So, for example, could Blake Lively be liable for defamation for Ryan Reynolds' alleged statement when he said that Baldoni was a sexual predator?
Potentially.
So the answer is yes. And would that trigger 47.1?
It should not.
Yeah. So there still is that avenue right there,
right,
which is kind of a more slender avenue, I think.
I still think the avenue that makes sense is for Baldoni to withdraw his defamation claim. He's still got other causes of action.
Against Lively.
Against Lively only.
Yeah.
And then you go full bore against Ryan Reynolds for if he did say that he was a sexual predator. That's certain. Those are words that are defamatory, and they do cause damage. And so you go after Ryan Reynolds, and then Stephanie Sloan. By the way, didn't Stephanie Sloan? I don't know if we want to get into this or not, but didn't Stephanie Sloan and her lawyers write a cease and desist letter to a content creator?
Yes, that's what I'm.
Stephanie Jones, Leslie Sloan. just to be.
Oh, I'm sorry. Was it Stephanie
It's-
Jones?
Yes.
Thank you. I know
She's
they're-
the
I
PR.
know they're both. I know they're both PR.
Or they both are.
Yeah, they're both PR people. I get their names crossed up.
I know.
So Stephanie Jones and lawyers. Thank you, Eric.
Yep.
Didn't they write a cease and desist letter to some content creator?
That's what I've seen.
And I think the content creator just published the cease and desist letter, which
Here it is.
is what most people would do. So
Yeah, right.
yeah.
Yeah, exactly.
Well, yeah, everyone always says, you guys answer the questions. I say thank you for explaining and thank you for the clear explanation. I'm learning here. So you're welcome.
Yeah, fantastic.
Well, yeah, I think that might be a good stopping point for today.
Yeah, sounds good.
I'm good with it.
Yeah.
I want to thank, again, everybody in the jury pool for their awesome support and awesome comments. That meant the world to me and my family. So thank you for that. I'm going to be an emotional wreck probably for the next 3 or 4 months here, but I still plan on showing up and working, and you guys just have to deal with me. So
Yeah, I know. More so than normal.
more so than normal.
But thank you for showing up, and hope you have a good rest of your day and evening.
We'll see you next time. We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.